Good morning, everyone. Welcome to the Pandemics and Leases, Current Leasing Issues and Examples of Future Lease Provisions to Consider webinar. Thank you for joining us. Ward & Smith is a law firm with 5 offices and over 90 attorneys. Today's speaker, Drake Brinkley, practices commercial real estate law. Today, Drake will discuss how COVID-19 has affected commercial leases in North Carolina, and he will address provisions to consider in future leases. Drake regularly represents both landlords and tenants across North Carolina in commercial lease negotiations for a wide variety of spaces, including office locations, retail centers, industrial facilities, and solar farms. Other areas of his practice include representing commercial real estate buyers and sellers in negotiating and closing purchases and sales, as well as representing developers and investors in all aspects of the land development process. Further, he assists clients with real estate issues associated with mergers, acquisitions, and company divestitures. Drake earned his law degree from Campbell Law School and his undergraduate degree in civil engineering from North Carolina State University. Before beginning practice, Drake clerked for Judge Douglas McCullough on the North Carolina Court of Appeals. We would like for today's webinar to be as interactive as possible. If you have questions during Drake's discussion, please type them into the Q&A portal within the webinar. We will also allow time for questions at the end. Drake, welcome. I'll turn things over to you.
Okay. Well, thank you, Jen. Thank you for that introduction. Hopefully everybody can see me. Thanks for joining us today, everyone. I was looking at the list of attendees for this, and I know a great number of you. So thank you for everybody for joining. For those of you I've never met, hopefully we can meet someday in the future. The reason I decided to host this webinar is because we have been getting a number of calls from various landlords, some tenants as well, just with general landlord-tenant issues in relation to COVID-19. As you know, many tenants can't operate or are operating at a limited capacity. And due to that, the tenants are wanting rent relief. Some are wanting rent abatement, some are wanting rent deferral. And so it's just, we're getting a variety of calls on these issues. I would say that we've been getting calls now since maybe mid-March on the issue. And we're coming up with just different ways of handling these issues. And so that's the main reason for this webinar today, is to explain to you the types of calls we're getting, how we're handling the issues, and how we may see things in the future. So we will start out today talking about the current state of affairs, what we're seeing and how we're dealing with those issues. And then we will shift gears and talk about leases in the future, what I think will be provisions that we need to deal with and think about a little differently maybe than we have in the past. And so we'll go to that sort of topic towards the end of the webinar today. I hope everybody gets something out of the webinar today, a little nugget or two to take home with you and that you can use in your work. I do want everybody to know that there's no silver bullet with this topic. It's very new. You know, the types of things that people are dealing with today, we just didn't deal with in February. And so there's not going to be a perfect solution. There are going to be some things to work out. Ultimately down the road, I'm sure there's going to be some litigation that some folks are going to be involved in, and that's just where we're going to be. But anyway, also note that, you know, we're going to be here today. I probably have about 30 minutes of discussion. And so it's a little snippet of the overall scheme of things. Certainly take what I'm going to tell you today and try to apply it to your situations that you're involved in. But at the end of the day, I'm giving you a snippet. And so you can't take one thing I tell you today and you might see this particular language or item in your lease and then assume that you're going to get to the same result that I may discuss today. So just bear in mind that you can't necessarily apply it in that way. So, okay, so we'll get started. The first thing I wanted to talk about was the current state of affairs. when government started issuing orders for businesses to temporarily reduce operations or just to temporarily stop operating, as you can imagine, everybody in the commercial real estate world got nervous, landlords and tenants especially. Tenants were trying to figure out how they were going to pay their rents. And what I saw, and this could be different for other lawyers, but what I saw is many of these tenants reached out directly to their landlords. I don't know if the tenants went through their lawyers first, but in any event, kind of the chain I saw was the tenants reached out to the landlords, said they were either going to quit paying rent or they wanted to pay a reduced rent or whatnot, and then the landlords were then calling us. That's the chain of events that I saw. Like I think I said, these calls started coming in, I'd say mid to late March. That's when they probably started. I'm sure that some of these calls are going to be kind of cyclical through the months because generally rents are due at the start of the month. I've spoken with a number of investors, brokers, landlords, tenants. I mean, I've talked to a lot of different folks, and people were concerned about April rents. People were more concerned about May rents. I think it's fair to say we're going to see an increase in concern as the months go by until people are back operating normally again. And it's also a little bit different depending on the space. And I mean, that makes sense. Certainly your commercial landlords in the retail space may have a larger concern right now than, say, multifamily possibly. But at the end of the day, everybody's concerned. And I do think it's people were much more concerned about May 1 than April 1. You know, the general discussion is the tenants are just not wanting to pay or wanting to reduce pay. Obviously, that leaves the landlords in a bad spot. Some landlords, I mean, for example, you have some landlords, well, maybe the tenant hadn't even moved in yet, and the landlord's in the middle of an upfit. And I mean, that's a really bad situation that you can run into. And the landlord not only is not getting any rent in, and maybe no rent was due yet, but the landlord's spending money for a tenant, and the tenant's saying they don't want to move in and maybe just want to terminate the lease altogether. And so it's really put landlords in a lot of jams. So what do we do? And I meant to tell you at the start, I'm sorry I may not have said this. Maybe Jen mentioned it at the very start, but as we go, certainly if you have any questions, use the Q&A function here. I'm more than happy just to stop. I think, Jen, if you send a question over the Q&A, Jen is going to let us know what that question is, and I'll do my best to answer it. We'll also have Q&A at the end as well, so if you want to hold your questions, that's fine as well. So, okay, so what do we do first? Well, obviously, the first thing to do outside of maybe call your lawyer, but if you have a landlord-tenant issue, the first thing obviously is to look at the lease. Look at the explicit language in the lease that may help out either landlord or tenant, depending on the situation. I've had a lot of calls, and we've had some emails about force majeure. What is force majeure? Those of you who are brokers and work in the space but maybe aren't lawyers, this is one of those provisions that's normally towards the end of the lease somewhere that frankly doesn't get the attention, or it will now, but it didn't get the attention before probably that anybody, well, it didn't get the attention that it was getting ready to get, let's put it that way. And so anyway, some people have asked me, just what is it? I mean, what is a force majeure clause? Well, it's a contractual provision that may excuse the performance by a party. And let me show you a quick example of one. I'm going to skip forward a slide here. This is an example of a force majeure clause. Now, let me tell you that these things come in just a huge variety. I mean, they really do. There's no way I can tell you this is the one you always see, because it's not. I mean, there's all sorts of different force majeure clauses. But as you can see, what it does is it lays out a definition for what is considered, it's a scope definition. If you see this language here, strike, lockout, labor dispute, inability to obtain labor materials or reasonable substitutes, act of God, governmental restriction, that's kind of the scope of the force majeure clause. And so some of these clauses are really, really broad. And if you look a little further down in this one, it says, or condition beyond the reasonable control of such party. Well, I mean, that's obviously pretty broad language, but some are not nearly as broad and some are much broader. And so the point is, this is a force majeure clause. This is the kind of thing when somebody says, well, do you have a force majeure clause in your lease? This is the kind of language that you might see that's typical. Now, it's not always called a force majeure clause. You know, a lot of leases, they'll have a little bolded language. They don't always call it that, but it may be hidden somewhere else. It could be hidden in another provision. But that's the kind of language that folks are talking about when they're discussing a force majeure clause. If you have one, it normally is explicitly in the lease. I'm gonna back up. There we go. It's normally explicitly there in the lease somewhere. But some questions, you know, as I said, the scope of the force majeure clause is very different from lease to lease. Does it excuse the payment of rent is always a question. There are some force majeure clauses out there that will have this big definition of scope, but then it'll say, you know, notwithstanding all that stuff, a force majeure does not excuse the payment of rent by the tenant. And so, and you see that quite a bit in leases, quite frankly. Not always, but sometimes. And so that's something you've got to look at too, is does the force majeure, is it a good defense for the payment of rent? Is a notice required? That's another thing that's important with a force majeure clause. So the point is that even if you have a force majeure clause, if you're a tenant, and even if you have a force majeure clause, it doesn't mean that you're excused from paying rent just because you have one. You really do have to analyze it. And quite frankly, I'm not a litigator. I'm a deal guy. I'm a commercial real estate attorney. I do deals. I don't go to court. But what I'm told is that there's very little case law in North Carolina on force majeure clauses as they relate to leases. You see them in the construction context quite a bit, but in terms of in the commercial leasing space, there's very few cases, I'm told, and therefore there'd be very little precedent. And so how the courts ultimately are going to analyze all these force majeure clauses in these commercial leases, I don't think anybody really knows right now. Another thing, if you are a landlord or a tenant, and this just goes without saying, but it's worth noting, make sure you document when any notices or communications are received from the other party. Very important because, as I say right above here, a notice sometimes is required to trigger the force majeure. So you need to make sure you document all those things. So I've shown you this force majeure clause. Like I said, it comes in many different flavors. Now, before I start on these resolution options, I do want to put in a little plug here. Warden Smith, we developed a tool which may be helpful for some of you, may not be helpful for some of you, but it very well may. And what it is we have on our website, if you go to our website, in fact, the firm has developed several tools through this COVID-19 process that are online tools to help folks. And one of those tools, there's a direct link, I think it's along the right-hand side of our website. It says something like online commercial lease review tool or force majeure tool or something to that effect. And anyway, you can click on it. There'll be a kind of an online questionnaire that you fill out, and all the information is there. But what it is basically a flat fee service the firm's providing. Flat fee service, you essentially, ultimately, you'll send in your lease documents. You'll upload them through a extranet thing we have. And essentially a lawyer on my team will review your lease for you in terms, it's a limited review. We're really focused on this force majeure issue. And so we can do that for you. We can get on the phone with you for 30 minutes. I think the cap might be an hour, but 30 minutes to an hour, we can discuss it with you. And so if that's something anybody's interested in, please use that tool. I think it will be helpful for some of you out there. Okay, so moving on. Resolution options. So what do you do if you get one of these calls? How do you deal with it? So obviously litigation and summary ejectment is kind of a pure legal way of dealing with this. And certainly at some point litigation is going to happen, I think. I mean, I don't see how it couldn't. The more and more money that gets tied up in these disputes, the more time that goes by, obviously the cost or the value of a particular dispute increases, and at some point there's going to be some litigation down the road. Summary ejectment, I mean, you don't really, kicking a tenant out right now, there are just not a lot of tenants lined up to take over the spaces, and so I'm not seeing any of this right now. I haven't heard of a lot of it from our litigators either. What we are seeing, which makes total sense for right now, I think for most folks, is some sort of agreement for rent relief. And so that's what I want to talk about, how we're handling those. First, you always want to do this in a lease amendment, a written lease amendment. It goes out saying, but there are a lot of folks out there that still want to do handshake deals, and you just don't want to do this here in this situation. We don't know yet. I still don't think we're going to know exactly where we're going to be 2 or 3 months from now. And if you're cutting a deal with a landlord or tenant today, you want it in writing. You really do not know where you're going to be a few months from now. So, and even if you did, you still want it in writing. So things to think about, because this deal that you're going to cut will be in the form of an amendment to your current lease. And I've got some topics here I want to go over with you. Is the deal an abatement or a deferral? Meaning, is it a full an abatement, meaning the tenant's paying no rent and they don't ever have to, just that rent obligation goes away temporarily? Or are you deferring the rent and they're going to pay it back at a later date? What I have seen so far is that tenants understand the landlords didn't create these issues. I mean, the landlord wants everybody to get back to business safely and as soon as possible. So deferral has been what I've seen. Many tenants that I've seen also are okay with kind of a rent reduction in the near future, with the rent to be paid back over time, maybe starting in the fall somewhere. And so that's what we've been doing for the most part. Base rent versus base rent plus additional rent. So be clear. I know you guys know this, but be clear. What is being, if it's abatement especially, are you abating just the base rent or are you abating everything? Obviously, if you're a landlord, you only want to abate base rent. So be clear in those lease amendments. You've got to go back. Don't just use little lowercase r rent in your lease amendment when your lease discusses base rent and additional rent. So make sure you're clear with that. Time periods. You want to use what I call dates certain on your start and stop times for everything. Do not use what I would call gray terminology. Don't say that, for example, rent is abated for as long as stay-at-home orders last or in place. We've all seen these stay-at-home orders are different at every level of government, it seems like. And you don't want to create, you want certainty when you have a lease amendment. You don't want to create further gray areas. And so, it's good to have a start and stop date for the rent abatement or rent deferral, and then when it might start getting repaid, start and stop dates. If the facts and circumstances around COVID-19 create an issue that was unforeseeable right now, the landlord and tenant may be back 6 weeks from now dealing with this again. And I hate to say that, but it could be true. But I would say do your best to use dates certain in these lease amendments. Confidentiality, very important in the multi-tenant spaces. You're cutting a deal with a tenant. You don't want the other tenants in the shopping center knowing what deal you cut with the first tenant. I would also say sometimes confidentiality is thrown into deals almost like a miscellaneous term at the end. It might be just, some folks look at it like almost like standard boilerplate in certain instances. This is obviously a different situation. And so it may even be worth pointing out to the tenant that, you've put a confidentiality provision in here and there's a reason for it. And so don't forget that sort of concept. Operational costs. I have no idea what it's going to cost landlords to clean their facilities, how often they're going to need to clean it. I'm not certain that you're going to necessarily be able to get this concept into every lease amendment. We're going to talk about it again in a minute when we get towards the end of my presentation here. I do think in leases going forward, new leases, that operational costs, when you're dealing with TICAM, that operational costs may start including real specific language about extra cleaning or something for pandemics or epidemics, that sort of thing. But that's certainly something that that's going to be important going forward. Finally, I've got a topic or an item here called third-party issues. These are things that are maybe not, they're not going to be in the lease amendment itself, but it's things that you need to think about when you're cutting a deal. For example, if you are involved in an LLC as a landlord, and you obviously would probably have an operating agreement, or you should definitely have an operating agreement if you have partners involved in that LLC, make sure that you are following any requirements of your operating agreement when you're entering into these lease amendments. Does it require some sort of, do all the partners need to sign off on this, that sort of thing? Don't forget your loan documents. Loan documents very regularly may have a prohibition on amending a lease without getting the lender's consent. Now, obviously, one issue with that is that I don't know how long it's going to take the bankers to get the consent that's needed here. And so if you're having to cut something right now, a deal right now, it's a judgment call about how you handle that with the lender. Some folks may cut a deal and not go to the lender, but I'm just telling you, keep in mind your loan documents would have that prohibition in there. The lenders are going to have to work with the landlords and tenants. I don't see how the bankers or the banks are going to not work with us. And so, and quite frankly, the banks have been working with the landlords and tenants a lot. And I'll talk about that here in just a second. But just don't forget your loan documents. Don't forget franchise agreements. If you've got one of those, depending on what the tenant is, if you're a tenant, you may have a franchise agreement. There may be something in there, very well could be. So keep that in mind. Let's see. Guarantees, maybe. I mean, if there's a guarantee in place, do you need, as a landlord, do you want the guarantor to sign off on the lease amendment? So just, you need to look at that issue. So back to the banks for a minute. Keep in mind that if you're a landlord, not only are you going to probably end up working out something with your tenant, you can go to your bank and maybe get some relief on your mortgage payment as well. The banks have, it's my understanding anyway, they've pretty much been giving out 90-day deferrals to most customers that are in good standing with the banks. They really have been working with folks. It's almost like a no questions asked thing. If you're in good standing, 90 days is my understanding. So sorry for the bankers on the line if you disagree with me, or if you want to clarify any of that, feel free to chime in on the Q&A. But that's been my experience so far. Let's see. All right. So on that, let me get the slide here. All right. So going forward, switching gears, what are we going to see in leases going forward? What do we need to think about, brokers, owners, when you're negotiating a deal? Is this something, are these, I'm getting ready to go through a list here, but are these the types of items that would be in a term sheet if you're a broker? I don't know, maybe. Maybe it is for the short term, but certainly I think if it's not discussed in a term sheet, it's going to get discussed. It's going to probably get put in the actual lease document. I do think in the short term, brokers, you're going to be dealing with this stuff because people are going to be asking about it. So whether or not it gets into the term sheet, I don't know, but certainly it's on the top of everybody's mind. And so I do think you're going to see more of this. So, what are we going to learn? What are provisions and terms to consider in leases going forward? Number one, how is rent going to be handled? If you're a tenant and you think there's a chance that we could be in this position again, the tenants may want almost like an alternative rent structure if certain things happen and trigger that alternative rent structure. So, and there'd be different triggering events, but tenants are not going to want to be in an immediate, well, not immediate, but end up being in a breach of their lease somehow because they're unable to operate even though they want to operate. And so I could see possibly alternative rent structures being triggered in the event, for example, the governor of the state where the property is located, issues a stay-at-home order or something to that effect. I haven't really thought about all the triggering types of events and how those definitions would work, but I could see something like that. I could also see tenants wanting, if they get that sort of thing, they want kind of on the back end of an epidemic, they might want kind of some time to ramp back up. So they wouldn't want the rent necessarily to go from alternative structure B back to alternative structure A just as soon as they can work again. So that could be that kind of a ramp up period of time. I could see that happening, and frankly, that's kind of working in back in those lease amendments we were talking about a minute ago. If you work out a dispute, I could see kind of a ramp up structure happening there as well. Obviously, the landlord doesn't want that. The landlord doesn't want alternative rent structures. The landlord may want something kind of the opposite. The landlord may want, it's almost like a deductible almost before alternative rent structures would kick in. So, for example, landlords may want a tenant to have to be not operating for 2 or 3 weeks before any sort of reduced rent kicks into place, if that makes sense. So those are kinds of things that I think people are talking about in the rent world, and it'll be interesting to see, because obviously rent's one of the most fundamental provisions in any lease, and it'll be interesting to see if this sort of thing actually occurs or not. Operation expenses. This goes back to the kind of the cleaning concept I was talking about. I just can't imagine how expensive some of this may be, and so I definitely think that in the forms you landlords have, brokers, you may have some form documents that you help some landlords with. I think explicitly putting in language about the cleaning or whatever else there may be for COVID or anything like COVID, that expressly is the type of thing that can be passed through to a tenant. Of course, tenants are going to want to cap these expenses because right now nobody knows what this stuff's going to cost. And just like tenants like to cap increases in operational expenses anyway. So it'll be interesting to see. I think once we get a better handle of what this expense is like and how much it really is, that'll obviously come into play here as to how important it is to work this in. Upfits. Many leases require a landlord to upfit the space. Those time deadlines for upfits are going to get interesting. Generally, you might have an outside delivery date if the landlord's doing the upfit for the tenant. Many leases already have a provision, or at least landlords try to work it in, where if the landlord's upfit is delayed for some reason outside of the reasonable control of the landlord, then the landlord gets a day-by-day extension of that drop-dead delivery date. So that the landlord doesn't find itself in breach, because many times those outside delivery dates allow for termination by the tenant. And so that's obviously the last thing you want to have happen if you're a landlord, is you're spending a bunch of money on a tenant upfit, something like COVID comes along, and the tenant can walk away from the lease. So I think we definitely need, you don't always see those day-by-day extensions, and I think you're going to see that more and more. Required operating hours. Many leases require the tenants to keep certain operating hours, and so I do think there'll be some carve outs there as well, because right now you might see carve outs for national holidays, and then plus X number of additional days per year, unless the tenant is doing some sort of major construction or something, which normally the tenant has to get the landlord's permission before they do that sort of thing anyway. But I think you're going to see some additional carve-outs for things like COVID. Force majeure, we talked about it earlier. I think that definition is going to be expanded quite a bit. You might actually see a whole separate provision in lease documents that are just dealing with these sorts of things. I don't know, but in any event, the general concept of force majeure, people are going to definitely slow down, definitely going to spend more time on it, and I think you're going to see form documents get an expansion of that definition going forward. So if you are a landlord, I do think it's a good time to look at your form documents and maybe start building some of that in. And then rules and regulations. You know, there are a lot of leases, especially in the shopping center context, where there are regulations associated with what a tenant can do outside of its space, maybe in along a sidewalk in front of the shop or store, maybe in the parking lot. And as we've learned from this COVID, you've got some tenants that are able to operate some, but they can't have customers inside their spaces. And so the issue becomes, can the tenant operate to some degree outside of their spaces in more of what would be considered common areas? And, you know, if a tenant thinks that they're going to be in this position again, they're going to want to have some reasonable right, I guess, to operate at some level out there. And so it'll be interesting to see how leases handle that, especially your restaurants and things that are in shopping centers, for curbside pickup and those sorts of things. I could see that working its way into leases. Now, of course, rules and regulations many times are set up. The provision of leases are set up to where a landlord can create new reasonable rules and regulations, so long as the landlord handles them kind of in a uniform fashion with the tenants in the various spaces in the center. What the tenants may want to think about doing is carving that out a little bit and say, well, notwithstanding that, you know, we're still going to be able to do X outside of our space or something like that. So I have come to the end here of my presentation. We may have some questions and answers we'll get to here in just a second. Before we get to that, I do want to say, if there are any other topics or anything in the future that any of you guys want, or anybody wants me to talk about, I'm happy to do so. I want to be a general resource for any of you on the line. You know, if you have any questions about the topics of this webinar, you know, if you don't want to ask them now, or if it just didn't pop into your mind until tomorrow, please reach out to me. I'm more than happy to try to help you. And if there are, I mean, I don't know if you thought this webinar was useful. Those of you who I know, I'd love to, you know, next time I see you, or if we're on the phone, if you'd give me some feedback, that would be great. And if there are any other topics that anybody would like in a future webinar, I'm happy to, you know, put something quick together and just discuss things with you. Jen, I think you're back on the line. Do we have some Q&A?
We do. So we do have a couple. Someone did ask how they can get a copy of this presentation. To everyone on the line today, I will send a PDF of Drake's slide deck, as well as a link to the recording of today's webinar to all participants. We do have one question that just came in. Do you have any suggestions to prevent things / negotiations from getting contentious quickly?
Yeah. One I did recently, I had one where I was working with a landlord. Tenant basically said they didn't want to pay rent. And, you know, to me, it's all about how you approach it. Now, you never know what the other side's going to do. But my theory is, right now, these are business deals. I mean, I just approach it by saying, look, we don't want to enter into a big back and forth negotiation on rent. You know, we generally speaking, and it's obviously something. I'll tell you, if you're a landlord and you have a mortgage on your space, it's always a good idea to tell the tenant, look, you know, I know you don't want to pay rent, but I owe my bank money, and so we've got to work something out here. And so now, of course, I mean, you may have that tenant that says, I can't pay. And I mean, if you get to that point, and, you know, yes, it could get contentious, but I think if you just go into it, the good thing about this, if there is something, is that everybody knows nobody's really at fault here. Nobody, I mean, the landlord's not at fault, tenant's not at fault. And so if you can get into just an open discussion, and I think the sooner the better, and to some degree, if you do that discussion yourself, that's fine. You may want to talk with your attorney before you have that phone call, so that you can have some of these bullet point things to talk with the other side with. You'll kind of know some things to discuss. Sometimes mistakes are made when a landlord or tenant goes into that discussion blind and doesn't really think the process through before they get on the call. So I would say, number one, I mean, it's okay to have some preliminary discussions, but if you're really going to cut a deal of some sort or try to, it's a good idea to talk to somebody, one of your attorneys first, and get some concepts and some bullet points to talk about, and then just go into it and say, look, we really need to work something out. And that's what I do when I'm negotiating. Now, obviously it can go down a different road, but there's no reason right now in starting and going down that different road. So I say, if you can just be as friendly and cordial as you can be on the front end, and then see where that takes you, that's worked for me so far.
Thank you, Drake. The second question is, how proactive should a landlord be in reaching out to a tenant about rent if the tenant has not asked for abatement or reduction?
That's a good question. I don't think you want to, if you're a landlord, you don't want to seem like you're ready for the tenant to ask for it. I mean, you don't want to start, if you're a landlord, you don't want to start a problem necessarily before you have a problem. If you have that conversation, and if you come out and you say something about reductions in rent, the tenant, depending on the situation, the tenant may just all of a sudden realize, oh, well, you're going to absolutely be open to it. So I mean, it's a good idea, I think, to be in contact with your tenants, and I don't think there's anything wrong with that, and that may be a good thing. You certainly, if you're a landlord, I mean, you don't want it to be a surprise. And so if hopefully, I guess my point is that if you have a good, healthy, open conversation link with your tenants, then hopefully your tenant would give you a little bit of a heads up before they're thinking about not being able to pay. But I don't know if I'm a landlord that I would necessarily want to start that discussion in any great detail that may give the tenant any idea that you're absolutely expecting them to reduce the rent. So, okay, Jen?
If you are a landlord, should you be talking to all of your tenants about whether they got a PPP loan?
Oh, well, okay. The PPP loans, and that can certainly help a tenant out. I'm not the expert on the PPP loans. Let me just go ahead and put that disclaimer out there. We do have folks that are very, very much so the experts in that area. So if you have any specific questions on PPP loans, I can put you in contact with those folks. And in fact, one of our little online tools, by the way, the firm has developed is on the PPP loans. And so it's this way to maximize your deferral of the PPP loans. So it's a really cool tool. But whether you're talking to your tenants about the PPP loans and whether they got one, I'm personally not aware of any sort of regulation that would keep you from having those conversations. So I don't think I'm not aware of that. Don't quote me on that, but I don't think there's anything that, from a landlord's perspective, that there's any regulation that prohibits you from asking the question. Certainly, and of course, I think there are certain approved uses for the PPP loans. And so that, if the tenants get them and they are able to use those funds for uses that are allowed, and then because of that, it also, and I can't remember what percentage may be used towards rent. I'm not exactly certain of all that, but I don't think it hurts to ask, but I'm not certain. Like I said, I'm not certain there's any sort of prohibition against asking those questions. And if the tenant gets them, I can't see how, you would think it would help, even if those dollars can't be solely used. I know a lot of it has to go to payroll and things. So I think it just depends. But I don't know that you need to be asking all your tenants whether they got one or not. I don't think you need to go that far. Sorry if that was a little vague of an answer, but I don't know everything about the PPP. I'm not the expert on that, but I do think it certainly could help if your tenant got the loan.
Thank you. How about smaller tenants whose landlords are huge national property owners who don't have their landlord on speed dial? How can you get those conversations going? How can you make sure they get heard? Should they call Drake?
I will say it certainly does not hurt. if you have a lawyer call for you, obviously it does get some attention, no doubt about that. And so long as whoever your lawyer is, I think in my experience approaches the landlord in a nice way and just says, look, I need to talk to somebody because you've got a tenant down here. And I understand you have a whole lot of properties, but you got a tenant down here that is in a bad position, and we need to come together. It won't take long, but we need to come together and cut a deal that works for everybody, or otherwise we're going to be in a worse position. So, when can we talk and how soon can we talk? And that's kind of, one of the ones, I had one kind of like that not that long ago, and obviously I can't get any specifics about it, but in that instance, it was kind of the reverse. Representing a landlord, but tenant was actually a really big tenant. They operated multiple states, many locations, and that's, you had to keep, you had to be persistent. You had to keep reaching out, have to reach out a handful of times, but eventually, got somewhere quick enough and got the deal cut. And so it does not hurt to have a lawyer call, I must say, in that situation, because otherwise you may be overlooked a little bit, and it does at least give the perception that you're serious, because you are. Not that you wouldn't be serious if you called yourself, but it has a little bit of a difference. I think it does make a little bit of a difference. So.
Great. It looks like we have about 3 more questions. So the next one is, as a landlord, what are some things I could require from my future tenants to make sure they could continue to pay rent during another pandemic? Proof of
Yeah. Well, could you have more of a security deposit there? Yes. And you could if you wanted a kind of a backstop on some of this, but depending on how long the pandemic lasts, that's the thing that's weird about this. We don't really know, right? We don't know right now when our tenants going to be back to normal, if you want to call it that. And so, taking an extra month security deposit isn't going to necessarily be the answer. Obviously, you're underwriting if you're a landlord, you're underwriting that tenant, and how secure they are, knowing what their business is. That will make obviously a difference. We have seen, obviously, one thing we'll learn through this is we know that some businesses can stomach this better than others, and that's just because of what they do. So that certainly needs to play a role in all of this. Is there an insurance product out there? That would be something to think about. You've got, and I'm also not an insurance professional, but I'll at least speak a couple of comments on it. There is business interruption insurance. Now, I will say that the discussions I've had on business interruption insurance, and I don't know if this is, I need to ask an insurance professional out there more on this. This is one of the things that's been on my list I haven't gotten to is, I have been told that business interruption insurance or lost profits insurance, things like that, may not kick in and provide coverage until there's been some damage to the structure, physical damage. Almost like those policies are written so that they're really written almost like as extra coverage if there's a casualty event. So, I don't know that I've been told that at least some insurance providers are not really providing any coverage for this sort of thing. So my guess is there's a product out there for everything. And so insurance, if there's not a product out there today, there'll probably be one out there. They'll be selling it 6 weeks from now. And so it'll be interesting to see where the insurance goes. I think that's a big question mark on this, is where insurance kind of, is there a reasonable product, and or what will that product look like if there's not one here pretty soon? So, okay, Jen.
As a tenant, if I vacate the premises, what could I potentially be on the hook for with my landlord?
Oh, wow. All sorts of things. Commercial leases are there are not many statutes in North Carolina that deal with the commercial leasing space when you compare it to, for example, residential. So multifamily might be a little bit different because there's residential leases would fall into that category. But I'm talking about your pure commercial, retail, office, those sorts of industrial, whatnot. So all sorts of things, because it really goes the gamut as to what the remedies are in the lease. You know, could I mean, so really, if you just leave, you may have possibly rent acceleration could be in there. Now, that's obviously a remedy that generally gets negotiated quite heavily. It's generally in most landlord forms, and most tenants obviously try to strike it. And so, but rent acceleration could be a real problem if you have that sort of provision in your lease. Now, if you don't have rent acceleration, lots of times you're going to have kind of a reasonable rental value. Whether or not there's a requirement for the landlord to mitigate damages would certainly be something I would look at. In North Carolina, there was a case, and I can't remember the date of it, but it was probably, I'm going to guess, 15 years ago or so, that back then said that if a commercial lease expressly states that a landlord does not have to mitigate damages if the tenant has breached, then the courts upheld that. And so, now if a lease is silent on the issue, normally there's a implied obligation for a landlord to mitigate damages. So that question is not easily answered on this, because it really depends upon what the lease says and what the various remedies are in the lease.
And we've got one more question before we conclude.
Okay.
Any thoughts on rent relief requests coming from brokers?
Say that one more time, Jen.
Thoughts on rent relief requests that are coming from brokers?
From brokers. Okay, so I guess I may not totally understand the question, but I guess what's happening here is maybe the request for rent relief, rather than a tenant contacting the landlord, I guess the tenant's broker is contacting the landlord. If that's the question. I mean, if the tenant wants to use their broker to do that, if the broker is okay doing that, then I mean, I can't. I mean, I'm trying to think what that may cause. I mean, that may help a little bit coming from a broker, kind of like if the call came from a lawyer. That may help. I don't know exactly what the brokers think about getting involved in this. I generally don't see brokers involved in lease amendments, quite frankly, not much. They do get involved some, but here you're talking about, I don't really know what would be in it for the broker to get involved, frankly. But if they want to get involved because they do a lot of work for a particular client and the client has asked them to get involved, then I certainly think it would help get the attention of the other side, if that's what the question is. If I'm missing the question, whoever's asked the question, just feel free to reach out to me afterwards or whatnot, and we can talk through it. But having a professional in the space, whether it be a broker or a lawyer or whoever, reach out to the other side, I don't personally see that as any problem. Now, I don't know all the broker ethics rules, but I don't think that would be any issue. But in any event, I think that would probably be fine. So, but feel free to reach out if I'm misunderstanding the question.
Great, thank you so much, Drake. Those were all of our questions.
Okay.
For those in attendance, as I mentioned before we started the Q&A, following the webinar, you'll be sent an email with more information on the North Carolina Commercial Lease Review Service that Drake discussed, as well as a link to sign up for our COVID-19 newsletters. We'll also make a recording of this webinar available. We so appreciate you taking the time to join us and hope you're able to take some of the information you learned this morning and apply it to your own business. Please don't hesitate to reach out to us with any follow-up questions you may have. Thank you again. This concludes today's webinar.